So welcome to Redfern Legal Centre's webinar, Financial Abuse in Family Law, Understanding the New Reforms. My name is Amelia Klein and I'm the Supervising Solicitor of the Financial Abuse Service. I am not a family lawyer, but I am the MC of the webinar today. I'd like to acknowledge the traditional custodians of the land on which we are joining you from. I believe that all of our presenters are joining from the land of the Gadigal people of the Eora Nation, and all across Australia we are on unceded Aboriginal and Torres Strait Islander land. I'd like to pay my respects to elders across this land, past and present, and recognise their ongoing stewardship of the land, sea and community. This webinar is held during National Reconciliation Week, which spans each year from the date of the 1967 referendum to the date of the Mabo decision, as a yearly reminder of the impacts Australian laws have on Indigenous Australians. And it's a time to learn about the rich culture and history of Indigenous Australians stretching back thousands of years. Today, we are incredibly lucky to be joined by a wonderful panel of presenters. We really appreciate the time that our pro bono partners give to both our clients in giving advice directly, and also in the generosity and time in being here for this presentation. Today's presentation is a collaboration between Bryan, Senior Associate and Accredited Family Law Specialist at Barry Nilsson, Skye, Special Counsel and Accredited Family Specialist, Accredited Family Law Specialist at Liebel Rogers, and Catherine Liebel, Family Law Solicitor at the Financial Abuse Service at Redfern Legal Centre. Bryan assists clients across Australia for financial, parenting and property matters in family law, is a former secondee solicitor for the Financial Abuse Service and a current volunteer. Skye was an associate to a federal circuit court judge before becoming a family lawyer and is engaged for expert advice on issues involving complex parenting and family violence matters, and was one of the first family law volunteers for the Financial Abuse Service. Catherine works exclusively with victim survivors of financial abuse, prioritising access to support for victim survivors, and has worked in the Financial Abuse Service since early 2024. Before we do kick off, I'll let you know in terms of the content, it does contain reference to family violence, which could be distressing for some viewers. This webinar will be recorded and available on our website afterwards. So if you need to take a break at any reason, it will be there for you to come back to later. If you need immediate or ongoing help in relation to issues raised in this webinar, we'd recommend contacting 1-800-RESPECT to talk to a counsellor from the National Sexual Assault and Domestic Violence Hotline. This is the outline of our presentation today. I will be monitoring the Q&A box for issues, including tech issues, and I will attempt to address any that I see, but if I can't get to them, as I said, the recording will be available, and I can't guarantee we'll get to any questions, as we did get a number come through in advance. But if you'd like to refer any clients for advice after this webinar, you can contact Falsintake, FALSINTAKEE at rlc.org.au. And now I'll hand over to Kath for the first part of the webinar.
Good morning, everyone. So next slide, please, Amelia. I'm going to start by just giving a quick rundown of the family law system, just because I think a lot of people present today are not actually family lawyers. So the things, basically what I wanted to do is just acknowledge that a lot of you here are not actually family lawyers. So I think in order to understand the system, I can just very quickly describe to you the way that the family law system works now. It's loosely divided into several areas. There's parenting, property, separation or divorce, child support, and spousal maintenance. These usually cross over and clients often deal with multiple aspects of this. The thing that I really want to outline and make you aware of now is that property does not simply refer to real estate. It's everything that's either owned or owed by the parties, and that's both parties. And property settlement is often confused for a real estate term. It's not. Property settlement is the division of the matrimonial asset pool. I'll just quickly talk about divorce. It's Divorce is simply a court order stating that a marriage has been dissolved. It's often used as kind of a catch-all term to mean divorce, separation, parenting, property, everything that's done. But a divorce itself is just the court order, and it does two things. It allows the clients to remarry, and it sets the clock ticking on a property settlement. Clients must either finalise their property settlement or file within 12 months of the date of divorce. De facto couples have to finalise the property settlement or file within 2 years of separation. And this is a question that comes up often. There's absolutely nothing that clients need to do officially to separate. They don't need to speak to Centrelink or anything like that. All they need to do is communicate it to the other party. And it can be good to get that done in a text message or something like that so that you have evidence in case anything comes up in relation to the dispute of the date of separation. Property at the moment is a 4-step process. It's the first thing that the court determines is what is the asset pool, and that's all of the assets and liabilities up to the present date, including superannuation and HECS. Then they look at contributions. So what did you come into the relationship with? What were the financial and non-financial contributions, the parenting, homemaker contributions, any windfalls or gifts? After talking about lottery for years, I've actually finally had someone who's won a substantial amount in a lotto recently. So that does come into it occasionally. We also look at future needs, so age, health, parenting responsibilities, and income earning disparity. And the final step is what would be fair under all of the circumstances. Now, this is the most relevant part of the current process for today's presentation. Just really quickly to touch on parenting, there's no time limit on a parenting application. So a parenting application can be brought before the courts at any time until the youngest child turns 18. The best interests of the child are always paramount, and changes to the legislation have already come into effect and came into effect on the 6th of May 2024. In relation to spousal maintenance and child support, the clients need to show two things for spousal maintenance: that they have need and that the other party has capacity to pay. It's often easy for our clients to show that they have financial need, but it can be hard to show that the other side has capacity to pay, and that'll depend on the circumstances of each individual case. Child support can be formal or informal. Informal, it's as agreed between the parties. So one side might say, I will give you $200 a week or something for child support, and they might just accept that. A formal child support agreement could be by assessment or a formal agreement. And there are two types of child support agreements: limited and binding. And I might hand over now to Skye to discuss the way things have been determined historically.
I'm just going to talk a little bit about how the law has dealt with family violence in financial matters historically. So the first thing I would say is the Family Law Act, as it's currently drafted, doesn't explicitly require the court to take into account family violence when determining a financial or a property settlement. I often find that this comes as a bit of surprise to some of our clients, particularly in circumstances where family violence does take centre stage in parenting matters. And it's also receiving, as you would all be aware, increasing attention through the media. So whilst arguably the court can take into account family violence as a factor when looking at a property settlement under a catch-all provision we refer to as Section 7520 of the Act, parties generally, historically, have been required to rely on case law when applying family violence to property settlements. In this regard, the landmark decision of Kennan and Kennan, which was determined in 1997, really revolutionised the way family violence was taken into account as part of property settlements. Before Kennan, courts were reluctant to take into account family violence as part of a property settlement, but once the decision of Kennan was determined, this became a precedent for the way you could factor family violence into a property settlement. Basically, a quote from Kennan which talks about the cases and the types of cases where Kennan could be applicable to a property settlement. Basically, the seminal passage in Kennan said that family violence can actually have a significant impact on a person's contributions, and as a result of that impact on the contributions from the family violence that they had experienced that could justify an adjustment to a property settlement. The full court in Kennan set out a rationale for this contribution-based assessment as a consequence of family violence, and in summary found that there could be adjustment if there had been violence and a course of violence over the relationship that made one party's contributions much more arduous as a result. To be relevant, Kennan said that the violence had to occur during the relationship and had to have a discernible impact on one party's contributions. This decision highlighted the profound effect family violence could have on a victim's ability to make both financial and non-financial contributions. Disappointingly, however, whilst Kennan was a landmark decision in this regard historically, it only talked about a limited application and referred to, and I quote, a narrow band of cases where this adjustment could be sought in a property matter. The Kennan adjustment, or as we talk about it, a Kennan claim, was subsequently born from this decision. But sadly and disappointingly, from my perspective as a practitioner, the application of Kennan principles since that decision has been fraught with challenges, including very high evidentiary thresholds and inconsistent judicial interpretations. So I'm just going to quickly move on to how the decision of Kennan has evolved since it was determined in 1997, and there has been some evolution of that decision over that time period. The first decision I look at is a case of Spagnardi, which was a 2003 decision where there was a focus on what the words, and I quote, discernible impact actually mean. In that decision, when looking at discernible impact, the full court found that there wasn't actually enough evidence in that case to establish the link between the violence the wife in that case had experienced and the impact on the contributions that she had made during the relationship. And Spagnardi said that there actually needed to be a clear link between the violence and the impact on the contribution. I recall just anecdotally a case I worked on whilst I was an associate in the old FCC. It was the only Kennan case that actually ran to a final hearing before my judge. And it was ultimately unsuccessful in relation to the Kennan claim, despite very, very compelling evidence, both from the wife and two of her adult children, about the family violence that she had experienced during a very long marriage. The reason why the Kennan claim was unsuccessful in this case, despite my judge's sympathy to the argument, was that there was no evidence adduced as to the discernible impact of the violence on that wife's contribution. So whilst the wife in that case ultimately did receive a significant adjustment, it wasn't on the basis of the Kennan claim, it was on the basis of some other factors. The decision was actually appealed from the husband on the basis that my judge had gone beyond her discretion in terms of the percentage outcome that was awarded to the wife, but it was upheld by the full court. So it was a great outcome, I think, for the wife in terms of the property settlement, but it does highlight at that point at least that there did need to be a link between the violence and the discernible impact. And as practitioners, our role in making sure that the court has that evidence before it to make that adjustment. Nevertheless, there have been shifts since that time as to how clear and that link needs to be. There's been some recent decisions where the court has said that inferences can actually be drawn between the impact on a person of a violent course of conduct. Obviously, to be, I suppose, quite frank, if someone's had a broken arm as a result of a violent incident, clearly that's going to have a significant impact on their contribution. They're not going to be able to make the same contributions that they previously did, or if they are still contributing, those contributions are going to be significantly more difficult. So more recent lines of authority have said that you don't actually need to be quite so clear in drawing that link. And I think that's a positive, that has been a positive evolution of Kennan. But it's still a difficult case to run, Kenan, currently, given how high that evidentiary threshold remains. Just quickly looking at a couple of other decisions, there was a decision of Britt and Britt. In that case, there was a focus on lack of specificity in terms of the evidence surrounding the family violence. So there was lots of words used in the evidence in that case, such as regularly, routinely, repeatedly, and often. The full court held that it was really important that there be detail given to the allegations of family violence when running a Kenan claim. And in that case, the full court held that the trial judge had confused admissibility of evidence with the weight to be given to it. So the importance of ensuring that the evidence was actually given in such a way as to allow the trial judge to put more weight on it, and as much weight as is needed to actually make those findings as to the violence that had been perpetrated. Lastly, I just wanted to quickly look at a decision of Keating. It was a first instance decision where there had been significant findings as to family violence, and that it was quite serious family violence, including physical violence. The wife's ribs had been broken, her nose had been broken. She had, as a result, suffered significant physical trauma and psychological trauma. But even though that evidence was provided, again, when we revert back to the decision that I spoke to initially, the link wasn't drawn. So in terms of the impact of that violence on the contributions that she was making. So even though the court has on one hand said that inferences can be drawn, in other courts there's a stricter application. So I think it's so important, and to actually, when we're running these cases, and hopefully with the changes that are coming in June, it won't be as strict, that we do turn our mind to not only deposing to the violence in particular detail, but also saying to a certain extent how that has impacted the contributions and made those more arduous on the survivor of family violence, for that ultimately to be taken into account. But what I might do now is I might pass over to Bryan, because a lot of this hopefully now will be historical when we're looking forward to the next phase, which is the amendments that are coming in June, because the amendments in June will actually be codifying some of these principles, and hopefully with that codification, we'll see the bar drop a little bit.
Awesome. Thanks so much, Skye. So we've just now had a look at how the court has historically taken family violence into consideration in these financial matters. And today we'll now have a look at the Family Law Amendment Act, which comes into effect in about 2 weeks' time, come 10 June. And so for the purposes of today, we'll be unpacking the property reforms, and more specifically, how family violence will be taken into consideration in financial matters for separating couples. So what we'll be covering in terms of some of the relevant amendments, which are significant, I think it's important that you try and keep these in mind to take away from today's session. So first, there's an expansion of the definition of family violence with respect to economic and financial abuse. There's in terms of how the court will now determine a property settlement under the new framework, there's now going to be a specific reference to family violence when considering, one, a party's contributions, and two, the current and future circumstances of the parties. And three, in terms of companion animals, there'll be a framework for determining pet ownership as part of a property settlement, and family violence as a relevant consideration with respect to that specific issue as well. And finally, there's also going to be a codification of these disclosure obligations under the Family Law Act. So as you can see, in terms of what underpins these amendments, it looks like the government has introduced these amendments in an attempt to try and make this decision-making process for determining property settlements to be more or less accessible for separating couples to navigate, and particularly for self-represented parties. And you'll see that there appears to be a strong message to the community here that there will be a recognition of the economic effects of family violence. So if I can now talk to the definition of family violence, and I'll try and refer to the slides where I can for those that are following later on or watching the recording. But with respect to the slide, which sets out the definition of family violence under the Family Law Act, first off, the definition will now clearly identify economic and financial abuse as a form of family violence. It appears that the intention is to capture a broader range of conduct, and it reflects that there are differing views and understandings now about the scope of the behaviour captured by economic abuse and financial abuse. Then there's a broadening of this definition, and it provides a list of examples under the definition of family violence, which is Section 4AB of the Family Law Act, and that might and those lists of examples of that behaviour might constitute economic and financial abuse. And here, it's important to remember that it's not an exhaustive list of examples which may form, which might fit under that definition of economic and financial abuse. But I'll just take you to some of the relevant aspects of this expanded definition. So first off, it expands the current example of unreasonably denying financial autonomy, and includes forcing a family member to take on a financial or legal liability or status, and forcibly or without the family's member knowledge, accumulating debt in the family member's name. And in our work, we see this arise in the form of the spouse, for example, being forced to sign a loan application or claim Social Security for the benefit of the perpetrator. Under the definition or the list, financial abuse can also constitute unreasonably withholding financial support for living expenses, and this abuse arises regardless of whether or not there is a financial dependency. And finally, there's now recognition of dowry abuse through the coercion of a family member hiding or denying receipt of assets in connection with the practice of dowry. And I just pause to note that it's important here that there's this recognition, because it reflects that dowry practices differ across cultures and can occur at any stage of the relationship. And this in turn recognises the issues experienced in our multicultural community. So you can see there's a lot in terms of the conduct and behaviours that may constitute financial or economic abuse as it's defined now. Now, turning to the property decision-making framework, for the purposes of the slides, if you're watching at home, the definitions set out there refer to married spouses, but there are mirror provisions which relate to de facto spouses, and you can see that they're back on, hopefully, in any event. But before we look at how family violence features in the decision-making process, it's important that we briefly have a look at the new framework. And at present, as Kath mentioned earlier, the Family Law Act doesn't currently identify the steps a court takes in determining property settlement. And these are the 4 steps that Kath mentioned earlier. The other thing to note is that the Family Law Act doesn't explicitly identify or acknowledge family violence as a matter for the court to consider when making orders with respect to the property settlement. And as Skye mentioned earlier, this is where parties have been required to rely upon that line of case law. So now the amendments seek to clarify the process of determining property settlement by setting out what the court must do. And if I could just summarise this new framework, the court must identify each party's legal and equitable rights and interests in any property and liabilities. So in other words, it's what's in the net asset pool available for division. And the court must also take into account the parties' respective 1, contributions, and 2, current and future circumstances. Now, if I turn to the specific amendments which consider the effects of family violence, see on the slide there that first, in the assessment of contributions, the court is to take into consideration the effect of family violence so far as it's relevant on the ability of the parties to make the contributions. So if we unpack that a little bit, here contributions may be of a financial, non-financial, homemaker or parenting nature. It can occur during the relationship and or following separation. And the court is looking at the effect, which means that it's looking at the party's behaviour and the impact on the other party. It's worth noting that here that, at least I think, that the intention is not to punish or order compensation for family violence, but rather it allows the court to consider the effect of family violence as a part of a holistic assessment of the parties' respective contributions at this step. So we've looked at contributions. Now we're looking at the next step, which is current and future circumstances. And in that assessment, family violence can be considered in two ways. So the first is there's now a specific family violence factor where the court is to take that into consideration and its effect, insofar as it's relevant to current and future circumstances of the party. But more importantly as well, family violence may have an impact on the existing factors which relate to other current and future circumstances. And this is referring to the list of factors under this subsection of the Act, such as the impact on the state of the party, the health of the party, their ability to earn an income, or their caring responsibilities. But for today, I think it's worth having regard to the sections which I've spotlighted there on the slide there under subsection 5D and E, which may be relevant in the context of financial abuse. So first, we have a look at wastage. It's where a party intentionally or recklessly has caused any material wastage of property or financial resources. And some examples include: 1, excessive gambling, denying a partner access to funds, unilaterally selling or transferring assets, so that can undermine a party's ability to access assets, or intentionally damaging the profitability of, say, a family business, which can impact the other party who may have had a shared interest in that business, or their income earning ability. And if we look at the other factor, which may be relevant, it relates to liabilities incurred by either of the parties. And this factor allows the court to, 1, consider the nature of the liabilities, 2, the circumstances related to them, and 3, the impact of those liabilities on the financial future of the parties. And so this may be relevant, say, on the effect of a party forcing the other party to take on a financial or legal liability, and that's a form of financial abuse, which I discussed earlier. So you can see here, the court's now mandated to consider family violence at the contribution stage and also at the current and future circumstances stage when assessing a property settlement. Amelia, if I can head to the next slide, if possible, where we now talk about spouse maintenance. Spouse maintenance is sometimes known as alimony in some countries. It's the financial support paid by one spouse to the other spouse in circumstances where they're unable to adequately support themselves. The amendment that you can see there now brings family violence to the top of that list of factors which is now to be taken into account by the court, which again is a recognition of the effect of family violence when considering the financial support to be provided between separating spouses. And the effect of family violence might be relevant here to assessing a party's need for maintenance. And by way of example, they may be forced to flee the family home as a result of family violence, and as a consequence, unable to afford the cost of alternative secure housing. Or another example may be due to their lack of financial autonomy during the relationship, their income and the income earning capacity has been adversely impacted. So if I could turn to the next slide now. So we've looked at the property settlement and spouse maintenance aspect. Under the new property reforms, there is now a specific carve out for companion animals, and there'll be new provisions which will apply particularly to pets when making property settlement orders to determine their ownership. And it needs to be, by way of definition, a companion animal. So, for example, it can't be, under the definition, a part of a business or stock animal. And in determining their ownership, the court will be able to consider factors which may include, and if you're having a look at the slides later on, I'll just draw on some of them that may be relevant: the extent to which each party has cared for the animal, any history of family violence during the relationship, and any history or cruelty to the pet by a party, and the attachment of a party or a child with a pet. So as you can see there, there's a recognition of family violence again as a relevant consideration when determining ownership of a pet. And unfortunately, we do see pets either as a factor of family violence or a reason why a victim may not leave the relationship. But under these amendments, the court has broad discretion now to make orders to transfer the companion animal to the other spouse or a friend or an animal welfare organization. So for example here, the court could order that a party temporarily surrender the companion animal to an animal welfare shelter, provided that they've consented to that transfer. And this may be relevant where a victim is unable to secure appropriate housing for themselves and their pet after fleeing the former family home. In terms of the, if we flick to the next slide, in terms of the other final amendment that I wanted to talk to, which relates to disclosure. At present, a party's obligation under this framework is to make full and frank disclosure of all information relevant to their financial circumstances. And that's set out under the rules. The amendments now will be elevating this duty of disclosure from the rules and codifying them under the Act now, with minor tweaks here and there. This will hopefully, my view at least, signal the importance of the financial disclosure obligations and hopefully to improve compliance, particularly where we often see perpetrators of family violence withhold financial information. And this has significant impacts on a victim's ability to, and as we see in our practice, accessing basic information, financial support, like social security, and even to reestablish themselves. And so there are consequences which haven't changed for non-compliance with the duty of disclosure, which are still significant. And this can range from cost orders to fines and imprisonments. So the court can also take that non-compliance into account when it's determining what orders to make in a property settlement or a spouse maintenance matter. So it's still relevant. It's just been elevated to the Family Law Act. I can see there, there's been substantial changes to how the court will determine property settlements and looking at the effect of family violence. I've given some examples of how this may impact our practice. I think I'll pass it over now to Kath to go through more specifically how these changes our practice.
Thanks, Bryan. I think at the outset, it's important to acknowledge that financial abuse is a social problem more than a legislative issue. And while the tides are slowly changing, there's still a pervasive attitude that what goes on behind closed doors is no one else's business unless it's physical violence, and that's where the police step in. Most family law solicitors would have been advising clients with these changes in mind for months because other than matters that have final hearing dates before June 10, most clients on their family law journey will have their matters dealt with under the new legislation. Anecdotally, at least in the teething phase, it could be that the changes increase legal fees, as in current compliance and readiness hearings, which are hearings that ensure parties are ready for final hearing and that determine the length of the trial, extra days are being added because of the need for cross-examination. It's a very small percentage of matters that proceed to final hearing, but it's these matters that determine how we advise clients because judge-made orders clarify the legislation. As lawyers, we always advise clients through the lens of a judge. The question we ask ourselves is, how do I think a judge is going to decide this matter based on the evidence before them? It's our job to help clients understand the risks and the benefits of proceeding to a final hearing, keeping in mind that family law is a discretionary jurisdiction, which means that judges can and do make different decisions based on the same set of facts. This is why you might hear family lawyers talk about a range of outcomes. We might tell a client, for example, that a fair and equitable split would be between 55 and 60% in their favour or something like that. Next slide, please, Amelia. With that in mind, I foresee that one of the most significant impacts these changes are going to have will be in the definition itself. I think there has been a shift in education and understanding in recent years, but financial abuse is still not widely understood in the community. People's experience of what is normal in a way to deal with finances is incredibly varied, and it's coloured by their culture, their personal values, and what things look like in their own family home growing up. The other issue is changes in a relationship that result in abuse are often so subtle that clients might not even notice their freedom being gradually stripped away. I often advise clients who question whether what they are experiencing is even problematic when to an outsider it looks absolutely horrific. A classic example of unreasonably withholding financial support that comes to mind is a client who was given an allowance each week for groceries and for any other spending. Her husband would go through all of the receipts, and bad things would happen if she spent any money that he didn't approve of. So to keep herself safe, she simply stopped spending money that he didn't approve of. And the allowance didn't increase for years and years. So the client simply started eating less so that she had enough food to provide her now teenage sons. But because this had happened so gradually, the client basically kept putting one foot in front of the other. And it wasn't until a family member pointed out that the situation wasn't right that she realized that it wasn't right. Being able to point to specific behaviors of perpetrators like that and tell the client it's not okay that this happened to you is a powerful tool when it's backed up by legislation that defines such behavior as abuse. In relation to how the courts will consider family violence, this has already been touched on, but one of the things that I want to highlight is that the update will not provide compensation for victim survivors. There are channels for compensation, like victim services. Lately, something that I've been making a very conscious effort to explain to clients is that this legislation recognises that family violence, including financial abuse, can impact someone's ability to increase their wealth and contribute to the balance sheet. It'll be interesting to see how the judiciary treat this in cases less overt than, say, for example, a concert pianist who had their hands broken and couldn't work, or in Skye's previous example of the broken arm, but rather a client who was forced to stop working as a means of control. I'm often asked about a scenario where a client gave up their career because the other side simply refused to contribute to parenting or homemaking and left them with no choice, or where they were forced into resigning by a controlling partner. Clients in this situation would have all of the disadvantages involving super, career progression, and so forth, and their future earnings would be impacted. This has previously been dealt with by looking at future needs, but now there may be an argument that this should be considered in terms of contribution. Of course, it'll depend on the strength of the client's case. It might be a difficult evidentiary burden to show that a client resigned because their partner forced them to. I intend to just keep advising clients to keep as many records as possible, so download and use apps like Empower or keep a diary if they can do it safely. It may be that in matters involving financial abuse, the changes will allow for greater judicial discretion in placing more weight on contributions being made, to use the old language, more arduous as a result of the financial abuse. I'd like to describe a hypothetical scenario of what I see on a day-to-day basis, where I think prior to the changes, it would have been almost impossible for such a client to get any adjustment on family violence. But I think this is a real opportunity for the courts to make some progress in this space. So the client began a relationship as a confident executive in the corporate world. She came into the relationship with significant assets. The other party had a high-flying job with a great salary, but he wasn't great with money and spent a lot maintaining a lavish lifestyle. The husband started his own business and convinced the wife to spend all of her savings on assets for this business. After the children were born, he convinced her not to return to her former role, as she'd be more useful working for him. She helped grow the business significantly, but was never paid a salary, as all money was family money. The client no longer had any access to funds that the husband didn't oversee, and she had to jump through various hoops, and I'll let you use your imagination about what that might entail, in order to access enough money even to buy milk for the children. This client couldn't see any way of leaving the relationship because she couldn't even pay for a bus ticket without the other side approving of the spending. This client ticks a lot of boxes in this new definition. My take is that under the current legislation, such a client would be eligible for a reasonably substantial adjustment for future needs and probably initial contribution as well. But with the changes, this client will be eligible for an adjustment based on her ability to contribute to the asset pool being significantly diminished on the basis of financial abuse and control. Next slide, please, Amelia. I want to talk a bit about the circumstances around liability and wastage. I really like the phrase forcing family members to take on a financial or legal liability, because this is something that we pretty much see every day in our work. I can think of one example where the perpetrator successfully took out a $7,000 loan in the victim survivor's name without her knowledge, using his brother's address, his mother's email address, and his own phone number. The finance provider had obviously not done the right thing in this case, but this is not uncommon. And many people don't know that they might have an avenue to challenge this. They just pay the debt down, even if it means going into significant financial hardship. Of course, this is straight up fraud, but it can be legal grey area where it's family involved, and often the authorities' attitude is that they should go and sort it out in the family courts. With the changes, such a case fits squarely into the new definition of financial abuse, and in this situation, clients may get a remedy where previously they would have struggled from a family law perspective. Bryan has already spoken about wastage quite a bit, but just briefly, it's my belief that the change will make this issue a bit more common sense. Currently, a wastage argument can be difficult, particularly when the funds have been spent on something that's socially acceptable. There can sometimes be a fine line between recreation and wastage, and so this in the past has kind of blurred this issue, and I'm thinking the changes will clarify and simplify this. The housing needs of children is going to be, I'm hoping it's going to be a big shift in thinking here. I will admit that I'm finding it difficult to speculate about the significance that it's going to have, and I think judicial discretion is going to play an enormous role. I've seen situations where the housing needs for children might have a profound effect on the division of the asset pool. For example, a client who hasn't worked for 15 years because she was raising 3 autistic children, with the children all being settled in support units at their local school, but the client having no capacity to earn an income. While there would have been a future needs argument previously, I will say I don't envy the judiciary's job of balancing this with a fair and equitable split, and I'm finding it difficult to speculate how much significance any particular judicial officer is going to place on this, so I'll be watching with professional curiosity. Next slide, please. This is about animals. Bryan's spoken quite extensively about this, and I think this is pretty much every practitioner's favourite part of the new legislation. I will say I've always found it really difficult to tell clients that by law their beloved pet has the same status as the coffee table or the iron. I've had a lot of clients in the past ask for what is essentially a parenting arrangement for their pet. This still isn't possible with the changes, but the new legislation is going to bring in some certainty for the pets and probably a lot of comfort for people as well. In relation to disclosure, parties have always had a duty to provide full and frank disclosure, and the courts have always had the power to impose significant penalties for non-compliance. But historically, it's been rare that these powers were fully exercised. One example that springs to mind is from 2018, where a judge famously told one party to either bring his disclosure material or bring his toothbrush to the next hearing, because if documents weren't there, then he was going straight to jail. Now that it's enshrined in the legislation, compliance may improve. In terms of practical effect, I'm hoping that it might mean that parties don't need to resort to subpoenaing financial institutions so much. I think most family lawyers have always taken disclosure pretty seriously and made this duty abundantly clear to clients. But one advantage for the lawyers is we can now point to the legislation if a client tries to shoot the messenger. But this update won't really change the way that I advise clients. Law is often made clear through what judges decide in final hearings, and many of these changes are attempting to enshrine widely accepted case law into legislation. Having said that, judicial discretion means a lot of these changes may be more of a watch this space than anything concrete that we can point to right now and definitively say this will be different, so watch this space.
Thank you very much, everyone, for those wonderful pre-prepared slides. We now will be jumping into our question and answer section. So the first question that we've received is, will these reforms also affect parenting matters? Bryan, you put your hand up to answer that one.
Yeah, I'm happy to discuss that, and happy for the others to jump in on that as well. But just from the outset, as Kath mentioned earlier, the amendments as to how the court will make parenting orders in the best interest of children were dealt with under the amendments of last year, which came to effect on 6 May 24. In terms of how the property amendments will impact parenting, not specifically, but in terms of parenting arrangements, which will be relevant given the specific new factor under the current and future circumstances. The one that just kind of comes to mind is the one that Kath mentioned earlier, the need for either party to provide appropriate housing for such a child. And I think it'll be interesting to see how the court will deal with that and the evidence that will be brought in support of that, because we're in a climate at the moment where the cost of living and we're looking at a hot market in terms of rentals and housing costs. These are all going to be relevant when we're looking at parties' ability to rehouse themselves, including their kids. And it will also have an impact on consideration of parenting arrangements, which will come hand in hand with that as well. And so that's where I see the flow and effect will occur from the property amendments into the parenting.
All right, if there was nothing else anyone else wanted to jump in with there. Our next question is in relation to protection of male and same-sex victims. The person has asked, saying that, is there anything in this reform that will specifically protect these victim survivors? They've seen in their practice that even if men do try and report financial abuse, they are ignored. Kath, I think you were going to speak to this.
Yeah, I'll jump in there. I think it's important to point out that sexism affects everybody, and the legislation is not gendered. So in my practice and in the FAS team, we advise people of all genders, and we speak to many people from all walks of life. And honestly, I think if you're finding that men aren't being believed when they're talking about an abusive situation, then it's probably worth speaking to a different organisation. They're probably not getting the right referrals, because we definitely believe male clients when they speak to us and explain that they're being abused as well. So perhaps consider some different referrals in order to get the right help for your client, if that's the case.
There definitely are specific organisations for male victim survivors, and if it involves reporting to police rather than in the family law setting, and they are a queer person, then there are options to speak to I think the official title is Gay and Lesbian Liaison Officer in the police stations, but they do assist people across the queer spectrum, not just gay men and lesbian women. So that is an option if they're facing some barriers with the police system specifically. One of the next questions was, we see victim survivors liable and financially impacted through inclusion of tax debt in property settlement, even for tax year that was incurred years prior to their relationship. Will there be any reallocation in the property pool to the person using violent? Will there be any ability to reallocate this in the property pool specifically only to the person who incurred it under the new laws? Skye, I think you were going to speak about tax a bit briefly.
Yeah, I'm quite interested in this area, because I think it's something that we see a lot, particularly through the Financial Abuse Service at Redfern Legal Centre. Sadly, for me, it's a really difficult question to answer, and I don't know exactly how I think the court might actually deal with this issue moving forward. What I would say is a general observation, or make a general observation about tax issues that come up in matters where we see serious family violence. I think that the tax office, and I may be wrong about this, but from my observations, they're lagging a little bit behind in terms of the processes that they have for dealing with cases. For example, how much the tax office will take into account potentially the violence one party experienced when considering whether that tax liability should be apportioned or not apportioned to that party. I don't know the answer to that. I know that there are working groups that are looking into this issue more broadly as to how family violence is taken into account by the tax office specifically. Another issue of concern that I have about these issues is re-traumatising survivors of family violence in needing to recount that history, not just through the family law process, but then also to the tax office in potentially defending a claim against them for penalties or outstanding tax liabilities. I know that it's difficult to share, for example, affidavit material in family law proceedings with external organisations. You'd need to seek leave to do that, but perhaps there needs to be consideration of broader information sharing between departments when family violence is involved. I guess what I'm doing is just throwing out potential issues without actually having any answers to the question that you asked, Amelia, but I think that this is a really interesting area for us to be looking at, particularly Redfern, to be looking at through the Financial Abuse Service, because I think that tax liabilities can often be very significant. They can often lead to negative asset pools and penalties. And if one party to a relationship has been forced through violence to acquiesce, then that should be given consideration, in my view, by the tax office. And it may be that it does under their discretion, but I think that it's not clear to me currently how closely that's taken into account. And I'm not a tax lawyer, so maybe for your next session, you might want to get a tax lawyer on here to discuss that.
I don't think it's clear to tax lawyers at the moment. It is an area that is, as part of the Economic Abuse Reference Group, which the Financial Abuse Service heads up. It's a coalition of organisations across Australia. It is an issue that we've taken up directly with the tax office, and we are working with them on it. And I think that, as Skye said, that's the space where the change will happen. It won't necessarily be in the family law, because as a not family lawyer, my understanding is those different types of debts, tax versus non-tax, aren't considered separately in the Family Law Act. Please correct me if I'm wrong.
Sorry, you just cut out there. I'm having very bad internet issues. I didn't hear the last part of what you said, Amelia.
The Family Law Act doesn't distinguish between different types of debt, really.
No.
It considers it all as debt, whether it's tax or not.
As long as they're crystallised, yes.
Okay. There was a question that might be the last one, depending on how long it takes. Will these changes be retrospectively applied? Is the first question for anyone to be able to answer.
I can quickly answer that. In terms of the different parts of the amendments have different commencement dates, but generally speaking, when we're looking at contributions and future needs, they will be retrospectively applied, provided that the matter's not part heard. Correct me if I'm wrong about that, Bryan, but that's my understanding.
Yeah, that's my understanding as well.
And the next part I think is a bit trickier. For clients who have been forced to settle before now, is there anything that can be done with these amendments?
Yeah, that is a bit trickier, because to set aside a final property order is a difficult thing to do currently. So there's a section in the Family Law Act that looks at setting aside final property orders that are made at section 79A. And there's a very narrow list of criteria that can apply in terms of setting aside a final property order, including material non-disclosure, fraud, duress. I can't think of them all off the top of my head, but I would say if any of those criteria under section 79A are ticked, then potentially, but generally probably not, would be my view, but I'm open to what my colleagues on the panel have to say about that.
I would agree with that, Skye. I think generally it's very, very difficult to set aside final orders and to relitigate.
Thank you, everyone, for your time and your effort. This is a really tricky topic, and a lot has still to be done, both within the Family Law Act and also with other systems that it interacts with. So I know everyone appreciates the time that you've taken today, and I, as on behalf of the Financial Abuse Service, appreciate your time, Bryan and Skye. Up on the screen now should be, with a barrier, I'm very sorry, an opportunity to provide us with some feedback, to give us some information about other learning opportunities you'd like in terms of legal matters. So you can either go to that link or scan this QR code and give us some information. The slides and recording will be available on our website as soon as possible.